Say get a new number.
It's either one or the other, isn't it? I'm just saying, what's the point of having determination? This is not, this is just, you know what I mean? Either you have a cause or you don't need it, so you can give it if you want to.
For sure. The screening will you can have everything.
All right. Circuit Court of the 9th Judicial Circuit and Lawrence County Court is now open. I'm ready to welcome the Chief Judge presiding.
All right, have a seat, everyone. We're on the record in 2016 CF 15738, 2017 826, State of Florida versus Marquise Lloyd. Would the attorneys announce their appearances? For the record, we'll start with the state.
Rick Ridgeway, State of Florida. Rich Buxman, State of Florida.
Roger Wade, on behalf of Mr. Lloyd.
And Ted Marrero on behalf of Mr. Lloyd.
And for the record, Mr. Lloyd's present and in the jury box. We're here on the defendant's motion to disqualify the state attorney. It was filed about 2 weeks ago. Mr. Wheaton, it's your motion, so why don't you start?
Yes, sir. What we are arguing is a structural conflict in this case. Mr. King representing the state and also representing the JAC as their chair or their commission. This all came to light in my mind after the Andrews case came in. The Andrews case, if you aren't aware, the Supreme Court held that defense attorneys and clients have a right to file their motions ex parte, in camera, when they're seeking experts. And because there's a need for a particularized statement of facts of the case, so the court can make a determination whether an expert is appropriate or not. And that, as your Honor knows, in that doing that, sometimes work privileges, client privileges disclosed. And so the Supreme Court held, as you know, that in those hearings, the motions are to be filed under seal ex parte. The hearings on the motions are to be in camera. And the Supreme Court acknowledged and pointed out that this goes not just to the particularized need, but also as to the experts that they're seeking and the expertise of the experts. And that's supposed to be privileged and confidential. And that for those hearings, the state is to be noticed about the hearing, but they're not to be present, and only the commission is to be present. What we have here is a scenario in which Brad King is wearing two hats. He's the state attorney prosecuting the case, and he's the chair of the Justice Administrative Commission. So the issue is, does that create a conflict? And after that case came out on May the 9th. On May 23rd, the Justice Administrative Commission had a meeting. They meet periodically, and at the meeting on May 23rd, it came to my attention that the commission voted not to renew the contract of Cynthia O'Shea, who is a mitigation specialist. She's been doing it for over 10 years in the state of Florida, and she's the appointed mitigation specialist in the Lloyd case. And although at the meeting her work in the Lloyd case was not addressed, it was addressed into other capital cases that she was working on. And the staff counsel for JAC had prepared a report and a memo for the commission to review. And in that memo, they had referred to, I have here marked for identification, an excerpt of the memo that was given to the commission, and also the minutes from the meeting on May 23rd. They've been marked for identification A and B.
All right, you've shown this to the state.
Had no objection.
All right, so you're moving those in?
Yes.
All right, so they'll be received. A will be received as defendants 1 for purposes of this hearing, and B will be received as defendants 2, Madam Clerk.
At that meeting, Ms. O'Shea was not present. Well, I guess she was noticed to me that she was not present. And there was no one there to defend her billing, just a review of her billing. In the excerpt of the memo, the report to the commission referenced the fact that Ms. O'Shea had, well, in her billing had referenced that she had been consulted with Dr. Gold as an expert in the case. So at that meeting, there was a disclosure of an expert that the attorney in that case was using. Also, at that meeting, referenced in the memo excerpt, there was a disclosure that she was doing research on brain science, which is essentially a disclosure strategy for the attorney that she was working for there. So, presented at that commission was
did that pertain to pending cases or concluded cases?
Well, in her billing, I don't know the answer.
All right.
Judge, to be honest.
Okay.
I don't know the answer.
Okay.
But I do know that mitigation specialists often do interim billing
Do they have to do interim billing?
if they want to survive.
Okay.
Because, as you know, capital cases can take years. So financially, they routinely, and in my cases, I routinely file motions to increase the cap of mitigation specialists, investigators, et cetera, so we can continue on with the work. Because generally, in those cases, there is a cap for attorneys, but in capital cases, it's just a statutory cap.
Right.
Whereas the cap for mitigation specialists and investigators is a cap the court imposes. And then when the investigator or mitigation specialist reaches that cap, then the motion is submitted to the court increases it. So there has to be, so they do interim billing.
In the billing process, how much information must be disclosed to substantiate the bill that's submitted and the payment that's being requested? In other words, can you say, as a mitigation specialist, consulted with another expert 2 hours? Or do you have to say consulted with a neurologist or a neuroscientist on brain disorder or brain function? I don't know. I honestly don't know. I've reviewed JAC billings that lawyers submit because I handle the hearings for motions to exceed the statutory cap for attorneys. I've handled 1 or 2 for experts, but not as many. Far more for lawyers than for mitigation experts or other kinds of experts. Do you know? Maybe you don't know how much detail is required. In other words, does the billing process itself inherently disclose work product?
My concern, Your Honor, is the likely threat of the disclosure, or the potential threat of disclosure. Because if they start reviewing billing and they see expert 4 or 5 times and they don't see who the expert is, then that could create a red flag as well. Why are they talking to the same expert over and over again? And to resolve that issue, we would have to disclose, well, I'm not talking to one expert, I'm talking to several experts and perhaps their names. Has Your Honor reviewed any interim billing by counsel?
Yes. By counsel?
By attorneys?
Right, yes, I have.
Because that's a concern as well, is how much detail, because these things are worked up by the JAC's legal staff, my understanding. And so when they see billing practices that are questionable, when I review this, they contact the attorneys or litigation specialists, investigators, on an inquiry about that, for justification about the particular bills. And there's an ongoing problem, and they feel that the issues are not being resolved, and there's no question about whether this person should continue in that capacity as a litigation specialist or as an investigator, then they some point create a report, submit it to the commission, make a recommendation. I also have here identification C that states the independent objection. This is the minutes from January 22nd. Days.
All right, any objections, state?
No, sir.
All right, so that's received as defendants 3.
Those minutes reflect on a meeting that took place in which investigators were brought up for the billing practices. Again, not associated with our case, but for in other cases, capital cases, and the JC legal staff created a memo and created a recommendation. They can only recommend things to the commission. No one has the authority to terminate the contract of an attorney, litigation specialist, investigator, except the commission. The JAC staff creates a memo, they do their investigation, and when they submit those facts to the commission, for them to make a decision on whether they're going to terminate a contract, refuse to renew contract in the future, which they did for Mr. O'Shea, or not take an action on it. And the minutes on January 22nd dealing with Diamond and Mann, I believe they were investigators, the staff, the legal staff, indicate what they do is they don't say exactly what to do to the commission. The commission makes the decision, obviously, because they're the only people that can terminate. And so the recommendation on January 22nd to the commission was to either terminate for cause or terminate for without cause for convenience. I'm not sure what that means, but it seems to imply this almost type of employment at will. So the commission can terminate an attorney or mitigation specialist or investigator either for cause or for convenience without cause, as reflected in the minutes. It almost creates an employer-employee relationship with the commission, because only the commission has the authority to terminate, to take an action on a person's contract. The JC staff creates the contracts, gets the approval from the commission for the wording of the contracts, the attorney, mitigation specialist, etc., sign those contracts. If there are issues with the performance of the contracts and brought to those folks' attention, and if those issues are resolved, then it's taken to the commission, then they take action. I would submit to the court that kind of a relationship could easily have a chilling effect on mitigation specialists or even attorneys, especially in capital cases where you have to, based on the guidelines of the ABA, where saying is, death is different, it requires incredible amount of work, requires, from a mitigation specialist standpoint, they're supposed to go back and look at multi-generational aspects of the family and look at neonatal care that the person received in the womb and school records, all this. There's a lot of work the mitigation specialist does. And I would submit to the court that with this kind of scrutiny, it could place a chilling effect on their work, with mitigation specialists knowing that they're going to be scrutinized and potentially have their contract placed in jeopardy based on their work or those kind of things. So, with the same would apply, I would submit to the court for attorneys working on the case, on all the work that's required to prepare a capital case. It's hard to imagine how, if a contract is, if a mitigation specialist, an attorney, or investigator has a recommendation to the commission for termination, non-renewal, or suspension, and that's going in front of the commission, and that person is given notice about the hearing, and they're given opportunity to be present if they choose, and they can submit a request to address the commission. And the commission can choose whether to allow them to address the commission. And the person has the authority, and it's in the bylaws, the only person who has the authority to recognize the person who wants to speak is the chair of the commission, which again is Brad King. And I would submit if a litigation specialist or investigator or attorney was to go before the commission to try to defend their work, that would certainly jeopardize attorney-client privilege, jeopardize work product, those kind of things. If the mitigation, like, again, I was not involved in that case, obviously, this Shea was on, but I can imagine if I heard that my mitigation specialist had to go in front of the commission to address their work, their billings, I would want to be present to be sure that the mitigation specialist did not discriminate any matters relative to your work product or attorney-client privilege. And what I've seen is no provision in the bylaws or to notify attorneys about experts, mitigation specialists, investigators having their contract called into question. So as I said, I think this is a structural conflict at this point now based on what's come out in the Andrews case, Judge, where the Supreme Court has said that the state does not attend those hearings, only the JAC Commission. Brad King is chair of the commission. Brad King has the authority, is the chair of the commission, to review memos from the staff. And the commission solely has the authority to terminate, renew, or suspend the contract of the mitigation specialist. And that authority is a systemic conflict, I believe, Your Honor. And based on that, Mr. King should be qualified.
Let me ask you one or 2 points just to clarify the record. You mentioned that Andrews talks about filing the motion under seal and ex parte hearing before the court. All of that happened in this case with notice to the state that the motion is being filed without describing what it is, and notice to the commission or that the commission can appear. But the commission didn't appear in Mr. Lloyd's case. Is that correct? They didn't come to because we had these ex parte hearings. They didn't make any appearance.
No, on those motions, they have almost a set response that we take no position on.
Okay.
However,
but they don't even look at the motion, do they? Because the motion has information in it that you don't want to disclose to the state.
There's an email address, pleadings@JAC.
Right.
So we send motions to that email, pleadings@JAC, because we can't.
Well, do you blank out the motion? Do you redact parts of the motion so they don't know what you're asking for?
Well, the situation, the motion has to state a particularized need.
So you might say, I want a neurologist. Or you might say, I want a fingerprint expert. Or you might say, I want whatever. But what I'm getting at is I thought that the motion in this case were filed so that you didn't disclose who you were asking for to anyone other than me.
That's one of the reasons. But the case law is clear that for an indigent client or defendant to get funds, they have to state a particularized need, not just they want this expert. They have to say why.
To me. You have to state that need to me. What I'm asking is, did you disclose any of that information to the commission or just to me?
Yes. Because they can't respond about the validity of that request without knowing what the need is.
And that motion you did not provide to the state?
Right.
But you provided to the JAC?
No. Get a response from them to get to Your Honor, for Your Honor to make a decision about what is appropriate to appoint the expert.
Okay. All right.
So the JAC, they're the watchdog, or they oversee the funding, and that's why the Supreme Court said they have a right to be present at the hearings to protect the state's interest in terms of funding.
All right. The JAC by statute is comprised of 2 state attorneys and 2 public defenders.
Right.
Okay, all right, thank you.
And I think the Andrews case kind of really moves the needle on this.
Well, let's say you are the public defender or capital collateral counsel, so that you don't have to. You can spend office funds. Is that right? But do you notify the JAC about the expenditure of any of those funds?
No, they have a budget.
They just take it out of their budget. Okay. All right.
Thank you.
Okay, thanks. All right, State.
The majority of this argument revolves around potential problems with this procedure, potential conflicts of interest, hypothetical conflicts of interest, things that could be a conflict of interest in other circumstances. There are only two grounds to disqualify the state attorney's office. First is demonstration of actual prejudice, actual future prejudice by the prosecutor remaining in the case. Mr. Weed is neither alleged nor demonstrated. The second is the fact that there is some appearance of conflict that is so great that it essentially calls into question the integrity of the entire process. Then the state attorney could be disqualified. Neither of those has been demonstrated here. My position is that on its face, the motion fails to allege grounds to disqualify the state attorney, that it should be denied on its face. However, I am prepared to go forward with evidence today to demonstrate that, in fact, there is no prejudice to Mr. Lloyd in this case. First, because there's no information that was provided by the expert that has flowed to the state attorney's office. To the state attorney, Mr. King in his role as commissioner or as state attorney. And so there's been no flow of information to the prosecution. Secondly, there's no interference with Ms. O'Shea's continuing to work on Mr. Lloyd's behalf, because under the provisions of the JAC, any case where she was appointed and was working on, they will continue to pay her under the terms of her contract, so she can complete her work on Mr. Lloyd's behalf and be paid. So there is no prejudice there. And that when you see the entire structure of it, there's not such an appearance of conflict in this case that calls into question the integrity of what we're doing here. We're prepared to go forward with the evidence and demonstrate that, and would like to do that.
All right, I think I would prefer an evidentiary presentation.
Okay. Now, we have two witnesses that are both available by phone. All right.
You all have talked about that before?
Yes, sir.
Okay. Ms. Martinez, good morning.
Good morning.
This is Judge Lautner in Orlando. Do you have a notary there in the room with you?
Yes, I do.
All right, would you identify the name of the notary?
Of course. Her name is Miss Jennifer Henderson.
All right, Ms. Pedersen, will you place Ms. Martinez under oath?
I certainly will. Will you raise your right hand? Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All right, thank you. Mr. Ridgway is at the lectern. I believe he's going to conduct direct examination, Ms. Martinez.
Thank you.
Would you state your name and spell your name for the court reporter, please?
Certainly. My name is Anna, A-N-A, Christina, C-R-I-S-T-I-N-A, Martinez, M-A-R-T-I-N-E-Z.
And what is your occupation or profession?
I am an attorney.
And by whom are you employed?
I am employed by the Justice Administrative Commission.
And what is your capacity there?
I am the General Counsel.
And how long have you been employed as the General Counsel for the JAC?
Since July of 2011.
And would you explain just briefly what your duties are with the JAC?
Certainly. As the General Counsel of the Justice Administrative Commission, my job is to advise the different sections of the commission that in the jobs that they do. We provide, one half of the House provides administrative services to 49 different judicial-related offices. These offices include the 20 offices of the state attorney, the 20 offices of the public defender, the 5 offices of the criminal conflict and civil regional counsel, the 3 offices of the capital collateral regional counsel, and the guardian ad litem program statewide. The administrative services that we provide these offices are in the nature of accounting, budgeting, financial services, and human resources. The other half of the House is referred to as the court-appointed section. Back in 2004, when the state took over the payment of private court-appointed counsel and due process vendors that assist them in the defense of indigent citizens, the JAC took on the task of reviewing and processing the billings submitted for those types of payments. And we have the court-appointed section, which includes a help desk, court-appointed auditors, court-appointed approvers, and the legal section, which works closely with the court-appointed section. JAC also has an IT section, an operations section, and the executive section, which I am part of. I provide legal services to these sections to maintain that they are operating in a legally compliant manner. I also advise the executive director on legal issues, as well as the commission when it meets.
And how many employees work at JAC?
We have 85 employees. 82 and a half of them are what are known as full-time equivalent employees. And then we have 3 OPS employees that work various percentages of part-time.
You mentioned the payment to court-appointed experts and attorneys. Could you know approximately how many such payments or transactions the JAC handles in the course of a year?
Certainly. In fiscal year 2016-17, we handled 66,366 court-appointed attorney and due process vendor invoices.
And would you explain what the process is when a vendor submits an invoice for payment?
Certainly. Vendors submit invoices for payment to JAC when the vendor has a JAC contract that basically allows them to be paid directly by JAC for services that they have offered to the court-appointed counsel. The first due process vendor will sign a contract with JAC. Once the contract is executed, a vendor might be an attorney might wish to hire a certain due process vendor to provide services, whether court reporting, investigation, expert services, or other during a case. The court-appointed attorney has to move the court for authorization to hire this vendor at state-funded expense. The court approves it and the order should contain the number of hours and the rate established for the vendor to provide these services to the attorney. Once the services are provided, or when the services reach a certain billing point or amount, the vendor will submit an invoice to the JAC. The invoice will contain the name of the case, the name of the vendor, a total of the services provided, and then there will be, hopefully by then, JAC will have received not just the court order appointing the attorney to the case, but also the court order authorizing the services of the vendor, and that will also be in the file. And then we receive this invoice with a billing invoice attached to the invoice. It's also uploaded. At that point, JAC Court Appointed receives it, and JAC Court Appointed Auditing Section reviews it for statutory and contractual compliance. If anything is missing, for example, if we don't have the order or if the order is insufficient, the vendor will be issued, the vendor and the court appointed attorney that is having their services done for the case will receive an audit deficiency saying JAC needs the following documents in order to process your billing. Once JAC receives the necessary documents or the necessary information requested, then JAC, the auditing section, will process it and then send it over to the JAC approval section. The JAC approval section, once again, reviews the billing, but this time for compliance with the requirements that the Department of Financial Services requires in order for them to actually and ultimately make the payment. Once it goes through the approval process, which we call the last I's here at JAC who see a billing, it is uploaded to FLAIR, which is the state accounting system, and it's uploaded to the Department of Financial Services. Once at the Department of Financial Services, a bill may be audited by the department and or not. If it's not audited and the department sees no issue with it, they will issue payment.
The invoices that are submitted to payment, what is your status in regards to being public records?
Our status, as far as these invoices, is initially contained in the JAC's position is initially contained in the court-appointed attorney contract as well as in the due process provider contract, basically alerting due process vendors and court-appointed attorneys that invoices that they send to JAC are billings. JAC does not require a detailed amount of information in order to process a billing. JAC only needs some information, and that is specifically covered in our policies and procedures. But the contract addresses confidential information and the public records requirement that JAC operates under, as well as JAC's policies and procedures. We make them aware of it. We alert them to the Kite versus Duggar case. We reaffirm the fact that we do not need specific confidential information in order to process a billing. We also show them examples of correct billings so that they are familiar with the amount of detail that we need, which should not be anything that would reveal anything of a confidential or would reveal attorney-client privilege. So that is JAC's position. If a court-appointed attorney moves to seal a case or to operate ex parte, then and the court agrees and seals the motions related to that case, then once JAC receives the order, a notice is put in that file basically telling staff that they are not to disclose the contents of that file unless they first get clearance from legal. And that is how we manage cases that are under seal or that have an ex parte order granted.
Would you explain briefly the role of the commissioners in the day-to-day operation of JAC?
The commissioners do not have any role in our day-to-day operation. The one person at JAC which communicates with the commissioner is our executive director, Mr. Rip Colvin. The commission meets at a minimum of twice a year. That's contained in the bylaws. And at that point, the commission is apprised of, by the executive director, via his executive director's report. After the executive director gives his report, which may touch on funding and other initiatives that JAC is either undertaking or other state programs that are going to be affecting the judicial-related offices that we serve, then I will give the legal and court-appointed report, which touches on court-appointed funding, court-appointed billing issues. Once a year, the commission approves changes to the court-appointed and due process provider contracts, and whatever other issue the executive director has given authorization to be presented to the commission. The executive director sets the agenda for the commission meetings. Other additional reports might be presented to the commission. For example, after the legislative session, the executive director will also present a legislative report. And basically just apprise the commission generally of all the business that is being conducted by JAC staff on behalf of the judicial related offices and court appointed funding and billing invoices.
I want to ask you about a memorandum. I know you and I have discussed this memorandum. You're aware of the issue before this court involving Cynthia O'Shea. You're familiar with that memorandum?
Yes, sir.
Okay. You have that with you?
Yes, I do.
Okay. To whom is it addressed?
The memorandum is addressed to Chris Martinez, General Counsel, and that would be me.
And who is it from?
The memorandum is from Alicia Davis, which is an Assistant General Counsel here at JAC, and Andrea Sistrunk, which is an auditor in JAC's court-appointed auditing section.
What is the date of the memorandum?
May 9th, 2018.
And what is it in regards to?
The subject matter of the memorandum is mitigation specialist Cynthia O'Shea and billing practices.
And what is the length of the memorandum?
The memorandum is 21 pages.
No, I move to admit the Exhibit 6A into evidence.
Any objections?
No objections.
All right, that's received.
Ms. Martinez, would you explain to the court what prompted this memorandum? What event occurred that led to this memorandum being generated?
I will. In order for me to get into that, it helps to know a little bit about how the JAC, how the auditing section is structured. We have 16 auditors. And these auditors specialize in different types of invoices. Some specialize in dependency court-appointed flat fee billings. Others specialize in dependency hourly court-appointed billings. Some specialize in court reporter billings. Some in investigator billings. These auditors will review whatever category billing they've been assigned to, and they receive them from due process vendors or court-appointed attorneys statewide. Right? So, the investigative auditor was having numerous consistent challenges over the past 2 years with Ms. O'Shea and her billing practices. And some of the billing practices gave the investigative auditor a pause. What brought this to a head was that on March 6th of this year, Ms. O'Shea submitted a billing invoice to JAC. When a due process vendor submits a billing invoice to JAC, basically uploads it into our online billing system, JAC doesn't receive it immediately. The first person it goes to is to the court-appointed attorney that procured the due process provider's services. The reason for that is because JAC is making payment on services that JAC has no knowledge of, nor has JAC received, and that is required under state law. So the court-appointed attorney must look at the invoice and the attached billing invoice and basically certify that he or she received the services, further certify that the services were satisfactory, and lastly, that the services were reasonable and necessary for the defense of the case. All right, so Ms. O'Shea submitted this billing invoice, and the billing invoice was certified by the attorney on that case about at noon that day. That billing invoice contained an invoice for services for 14.7 hours on the day that it was submitted, when in fact it had been submitted prior to the day even 14.7 hours even occurring within that day. Additionally, and more problematic, was that it also contained charges for services that had been rendered in dates in the future, March 7th, 8th, 9th, and 10th. Given the amount of back and forth that we had had with Ms. O'Shea over the years in trying to instruct her on how to appropriately bill for her services, and given the fact that we've had quite a bit of success with other mitigation specialists, we figured that this problem had gotten to a point where it was raising even other concerns, not just perhaps sloppy billing, but also perhaps fraudulent concerns. So at the next legal meeting, I asked Ms. Davis, one of my assistant general counsels, who's been here at JC for a year and could give this a fresh eye, to please review Ms. O'Shea's billings for the past 2 years. And she worked closely with Ms. Strunk, the investigative auditor, and they produced this memorandum.
So it's accurate to say that this is a result of a decision that you made?
Yes, sir.
Were any of the commissioners generally, and Mr. King specifically, involved in your decision to ask for this review and memorandum?
No.
To your knowledge, were any of them aware that you were making this review?
No.
Once the memorandum was completed, what happened to it next?
Okay, once the memorandum was completed, I gave the memorandum to the executive director for him to review and determine what step to take next.
And ultimately, what was the decision made about the memorandum?
The decision was that this memorandum would be taken up at the next commission meeting in May.
Now, in the memorandum is two cases which are currently pending in the Ninth Circuit, State of Florida versus Markeith Lloyd. Was either of those cases referenced in the memorandum?
No, sir.
And when it was submitted was decided to put on the agenda for the commission itself, how are the commissioners made aware of the memorandum?
Well, as I said earlier, when I present to the commission a legal and court-appointed update. That is basically a document that summarizes all the different topics I'll be discussing with the commission, and the majority of the topics that I present to the commission has some supporting documentation, an exhibit, if you will. And that's when the memorandum was made available to the commissioners. Typically, we release commission meeting materials 2 to 3 days before the commission meeting, so that the commissioners have the opportunity to review the materials. The materials are lengthy, and when fully compiled, can be anywhere from 150 to 250 pages. So that's when the commissioners would have received the memorandum, which would have been May 21st, at the evening of May 21st. Typically, the commission meets on a Tuesday, and we release the commission meeting materials on the Friday before the weekend. Since this meeting was on a Wednesday, May 23rd, the commission meeting materials were emailed to the commissioners Monday, May 21st. The commission...
Were you present for the meeting and the discussion in regards to the memorandum and the decision about Ms. O'Shea?
Yes, I was.
And during that discussion, was there any discussion whatsoever in regards to Markeith Lloyd or the cases now pending in the Ninth Circuit?
No.
And after the discussion, was Ms. O'Shea noticed at this hearing?
Yes, she was.
And would she have had an opportunity to appear in person or by phone if she chose to do so?
Yes.
Did she appear?
No, sir. And during the meeting, I asked several times, not only for Mr. O'Shea's benefit, but for the benefit of other people that were also being considered by the commission, if there was anybody on the line and if anybody wanted to speak. And there was no response.
And what was the action of the commission in regard to Ms. O'Shea's case?
In regard to Ms. O'Shea, the commission decided that JAC would not, our contract with due process vendors and court-appointed attorneys runs for one fiscal year. In other words, you sign one each fiscal year, the next fiscal year's contract supersedes yours. The fiscal year for the state runs from July 1st through June 30th. Ms. O'Shea's current contract runs through June 30th. The commission decided not to renew her contract for the following fiscal year. The commission also asked JAC to do a further inquiry into Ms. O'Shea's billing practices because the memorandum only captures billing practices and patterns in the previous 2 fiscal years. Ms. O'Shea has had a contract with JAC since 2008.
And who made the motion not to renew the contract?
I believe it was State Attorney Brian Haas, the other state attorney on the commission.
And were there seconds?
It was seconded by the 2 public defenders, Commissioner Diamond Liddy and Commissioner Kathleen Smith.
And what was the vote in regard to not renewing their contract?
The vote was unanimous.
And does action by the board require a unanimous vote by the board?
No, it requires a majority vote.
So one member either abstaining from voting or voting contrary would not change the outcome?
That is correct.
Now, what is the effect of the board's action in regard to current cases such as the one we're dealing with now where Ms. O'Shea has been appointed to work as a mitigation specialist?
She will be able to continue to provide services in cases in which she was retained when she had a contract.
And even in cases currently, would she be prohibited from being paid by JAC for work in the future?
No, sir. She has 22 current cases with the JAC right now on which she is working on. In those cases where she was retained by a court-appointed attorney and she had a contract at the time, she will continue to be directly paid by JAC. The commission's direction for JAC not to renew her contract will only affect future retention by court-appointed attorneys after July 1st of this year. In those cases, Ms. O'Shea will have to be paid by the attorney, and then the attorney will have to seek reimbursement for her services from JAC.
But in proper cases, JAC would ultimately pay for her services.
In all cases, JAC will ultimately pay for her services. The commission's decision for us not to renew with her, basically what it does is that it takes away from JAC's court-appointed auditing staff the initial requirement of having to basically sift through her bills.
Thank you, Mr. Martinez. I have another question.
Before we go to cross, there was one, that last question I just want to ask for clarification. In this case, if Ms. O'Shea bills into the new fiscal year, so after July 1st, would she get paid directly by JAC or would Mr. Whedon have to front the money and then apply for reimbursement?
She will get paid directly by JAC.
All right. If another attorney in a case in July sought her appointment, then that attorney would have to pay her and seek reimbursement from you?
Correct.
Okay. All right. All right. Cross, Mr. Whedon.
Ms. Martinez, the memo you submitted to the commission back in May, was that on closed cases or ongoing cases?
I'm not sure. It was basically, Ms. Davis was instructed to look into billing submitted in the previous 2 fiscal years. Whether some of them have closed out or not, I have no idea. It's basically the invoices that JEC received in the last 2 fiscal years. That was our focus.
So when the memo has an excerpt in which Ms. O'Shea references a Dr. Gold, so you would not know whether that was an active case involving Dr. Gold?
I have no idea. No, sir.
Now you say that only the commission has the authority to terminate the contract, correct?
Yes, sir.
And the staff creates the memos, does the research, and then you review those and present. Do you prepare the memo, or someone else prepare the memo to the board?
Ms. Davis prepares the memo. What I presented was the court-appointed report, which basically summarizes what's contained in the memo briefly.
You say that when it goes before the board, the person in regards to the memo was written for, is given notice about the hearing. Is that correct?
Yes, because when we do a billing inquiry and we notice patterns and trends in someone's billing, the first thing that we do in our process is that we reach out to the vendor or the court-appointed attorney and say, JC has found these instances, and the first thing we'll ask for is we'll ask for notice of inspection of contemporaneous records. So we'll ask them to provide us with any supporting documentation that supports their billings, right? And then once we receive them, we may, and review them. If they're sufficient, the billing inquiry ends there. If we find that they're not sufficient, we may ask for more information from the due process vendors themselves. Sometimes we've even asked, we found this irregularity, what are you going to do to cure this in the future? So this has been going on, with Ms. O'Shea in the loop. When finally we got her contemporaneous records and they were reviewed and the memorandum was done,
I want to ask you another question. Okay? I just wanted to know whether or not the person had the opportunity to come to the meeting or telephonically and give a response. And the answer is yes, correct?
That's correct.
Okay. And so do you notify the attorney that has employed that person about the meeting, about that hearing?
I do not believe that we did. We asked Ms. O'Shea. We notified Ms. O'Shea.
So the attorney not being notified is not able to appear and address or protect attorney-client privilege and work product, are they?
They may be able to. I mean, the attorney can appear. It's a public meeting, and all the attorney would have to put on their speaker appearance form is, I'm the attorney involved in one or a few of these billings, and I would like to. The attorney would put that on their speaker appearance form, and then it would be up to the chair to recognize them or not.
But they're not notified.
No, they're not notified. It's JAC's assumption that the due process providers work hand in hand with the attorneys on the case, and if they're having an issue with JAC, that they would discuss that with their court-appointed attorney.
That's your assumption?
Yes, sir.
Now, the chair has the sole authority to decide whether to allow someone to speak or not, correct?
In order to speak at a meeting, in order to maintain order, you must be recognized.
Is that a yes or no, ma'am?
Yes.
And that chair is Brad King, correct?
Yes.
Okay. So under the bylaws, Brad King could say, I'm not going to hear from you, correct?
That is possible.
That is allowed under the bylaws, correct?
Yes.
Now, the commission, in effect, has the purse strings for the vendor funds and for the attorney funds, correct?
We administer them, yes, we do.
Right. For all indigent clients that are under court-appointed attorneys.
Yes.
And the commission has the sole authority to discharge or terminate the contract of a mitigation specialist, correct?
Yes.
So in the middle of an ongoing case, the commission upon a recommendation, could terminate the contract of a mitigation specialist that was working on an active case, correct?
That is correct.
And they can do that with or without cause, correct?
They can do it with cause.
Well, you also on occasion make a recommendation for termination either for cause or for convenience without cause. What does convenience without cause mean?
Convenience without cause is it can mean many different things. It can mean that the billing practices of the person are so difficult to deal with despite many efforts, and that it is taking up way too much time of the commission to try to process these billings, and therefore that would be a termination for convenience without cause. With cause is when JAC has reason to believe that there is fraud.
So you can't. So the commission can discharge a mitigation specialist in the middle of a case without cause, correct?
Yes, they can. No, what they can. They can terminate the contract, but they still could provide services in their existing cases. It's only when they are terminated with cause that we move to have them discharged from ongoing cases.
So the commission can make a decision to terminate someone with cause without allowing them to speak and without allowing the attorney to speak, correct?
I guess that is possible.
No other questions.
It has never happened.
Any redirect?
Just briefly, Your Honor. Ms. Martinez, as in regards to Ms. O'Shea, was there anyone who appeared to speak on her behalf or who denied to speak on her behalf who was not recognized by the chair or not allowed to speak?
No, sir.
Thank you. I have another question.
Ms. Martinez, I have a couple of questions. I know you testified that you audited 2 years worth of Ms. O'Shea's billings, and she's been billing the commission for maybe close to 10 years. So in the audit, let's start with the audit. In the audit, when you asked for whatever it is that you asked for, did Ms. O'Shea ever object or respond that you're invading any privilege, work product, attorney, client, any of the evidentiary privileges recognized under Florida law?
No, sir.
In the 9 to 10 years of billings, when you've questioned billings, have you ever received that response from her that you know of?
Not that I'm aware of.
So when, separate from Ms. O'Shea, just in general, not focusing on her case, my concern is if you question the adequacy of a vendor's bill and you require them to provide you more information, what you mentioned that there was a policy or contractual language about privileged information. What safeguards, if you need more information before you're going to pay someone, what safeguards are there so that they're not disclosing to you information that would be privileged?
Just a second, please.
All right. Why don't you talk to your attorneys real quick and then talk to your attorneys because they have to make any legal objections at this point.
Okay. Just let me know when you want me to speak.
Yeah, just give me 1 sec.
Take your time.
she's not able to answer that question.
Yeah, if she's looking at something, I think she should tell us what she's looking at. But my question is, what safeguards are there if the JAC is saying to a vendor, we can't provide you the money you're requesting because we need more information? What safeguards are in place to make sure that the information they're asking you or the elaboration they're requesting does not invade a privileged area under Florida's evidence code? And then, Miss Martinez, apparently you were looking at something. I don't know if you're looking at your report or you're looking at some contractual language. And since you're not here with us, I think Mr. Whedon's concern is he has the right to know what you're looking at while you're answering this question. I think that's the nature of his objection. So if you can identify that for us, that would help.
Of course. Of course.
So start with that. Did you look at anything to answer this question?
Yes, I did.
What was that?
I am looking at the contract for payment related to due process services provided to indigent defendants other than attorney's fees. This is the type 1 contract for due process costs that Ms. O'Shea would have signed. I also have with me the policies and procedures for due process vendors. Okay?
All right, go
now,
ahead.
in the contract, if you look at the contract and you go to page 11 of the contract, section 8, Roman numeral 8, entitled Record Retention / Audit / Public Records, and subsection 2 of under Roman numeral 8, it's the following. You'll find the following language. To the extent that vendors' records constitute public records under Florida law, vendor must comply with the requirements of Chapter 119 and other provisions of Florida law relating to public records. Vendor is solely liable for any fees or costs against the vendor if vendor fails to comply with a request for public records pursuant to Florida law. That's when a public records request is made directly to the vendor. Vendor should consult with attorney prior to disclosure of records to ascertain whether the records may be protected by the attorney-client privilege, work product privilege, or the principles set forth in Kite versus Duggar, 574, Southern 2nd, 1066, Florida, 1990, which concluded that files held in furtherance of representation of an indigent client are not public records. That's in the due process vendor contract, and it is also in the court-appointed attorney contract. You can also find more on this very same discussion in the policies and procedures under public records.
All right, thank you, ma'am. That's all I have. Any follow-up questions? All right, thank you, Ms. Martinez.
You're welcome.
I want to go on record. I object for simple fact. Can't nobody testify and go up and testify and take no notes of them.
Yeah.
I wouldn't even agree with
Mr. Lloyd, you have to.
Testifying on the phone.
Your objections.
Can't take no notes with her.
Your objections have to be made through counsel. You can't make legal objections. They have to make the objections. I understand that, but they have to make the objections as opposed to you. So you can't make legal objections, but they can. And you can consult with them, and if there's anything that's interfering with your ability to consult, let me know that, because you can consult with them, but they have to make the objections.
I think that those contracts that she's referring to should be printed and
Well, I would think they might be subject to public records requests, but at any rate, if you want...
the next contract is online.
Okay. Is there something else you want? Is there something you want that you don't have?
If you're honest considering that, then it should be part of the record, the contract.
I'm just considering her answer, so I mean, if you want me to look at some contract, I will, but I just wanted her to answer that question for me. Okay, thanks, Ms. Martinez. All right, do you have any other witnesses?
Yes, Your Honor. Also on the phone.
Now, do we need to hang up and redial, or probably? I guess we're gonna. Okay.
I can barely operate my own phone.
6 seconds.
sure who you called, so. Oh, Mr. King. Mr. King, can you hear us?
Yes, sir, I can hear you.
All righty. Is there a notary there for Mr. King?
Yes.
Mr. King, would you identify who the notary is?
It's my secretary, Debbie Allen.
Debbie Allen?
Yes, sir.
All right.
Allen.
All right, very good. Ms. Allen, would you administer the oath to Mr. King?
I do. Could you hear her?
Couldn't hear her.
Okay, you have to come around here. Speak right into the speaker.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Ridgway.
Will you state your name, please?
Bradley Eugene King.
And what is your current position?
I'm the elected state attorney of the 5th Judicial Circuit of the state of Florida.
And are you also affiliated with the Justice Administrative Commission?
I am appointed by the Florida Prosecuting Attorneys Association as one of the 2 state attorneys on the commission.
And how long have you been a commissioner with the JAC?
At least since 2010, I believe.
In your capacity as a commissioner with the Justice Administrative Commission or your capacity as state attorney, has any information been provided to you directly or indirectly in regards to the billing of Cynthia O'Shea in regards to her work on behalf of Marquis Lloyd?
No.
Are you aware of any billing that she has submitted for work done on that case?
No.
And to your knowledge, has any of your staff or anyone associated with the prosecution received any such information?
No.
And do you have any intention in regard to seeking such information?
My intention is I would not seek such information.
And if it were offered to you by some other person, what would be your intention?
I would decline to review it or look at it in any way.
Thank you. I have another question.
Cross. Any cross?
You're the chair of the commission, correct?
I am the chair, yes, sir.
And JC staff, they prepare memos from time to time to submit to the commission.
Yes, sir, they do.
And in regards to, have you had occasion in the past to vote to terminate the contract of any attorney or mitigation specialist?
I don't know specifically about attorneys or mitigation specialists, but other investigators we have, yes.
And you yourself have voted to terminate the contract, existing contract of investigators in capital cases, correct?
I don't know whether they were in capital cases or not.
So they were JAC contracted investigators, correct?
Yes, but JAC contracted investigators work on any case where somebody is assigned because of conflict, or they are deemed to be indigent for costs. So it's not just capital cases.
You have the authority in the bylaws to allow or disallow someone to speak at the meetings, correct, as the chair?
I honestly don't know that. I don't know that to be true.
You would not dispute that it was in the bylaws as testified to by Ms. Martinez, correct?
I wouldn't dispute that I might have that power, but I can tell you I've never refused to allow anyone to speak.
Any redirect?
No, sir.
All right, thank you, Mr. King.
All right, thank you.
Any other witnesses for the state?
No, Your Honor.
Any witnesses for the defense?
No, Your Honor.
All right, argument? You want any closing argument?
Just briefly, Judge. You know, the Castro case, the issue about whether there's an actual conflict or potential for conflict, or whether there's an appearance of impropriety, contrasted with speculation, and I think we have here more than just speculation about potential conflict. Clearly, what we heard from the testimony today, from what's seen in the exhibits in this case, this hearing, the commission has full authority over mitigation specialists, over contract attorneys, over investigators to make a decision about contracts. They essentially hold the purse strings, and they can terminate somebody for cause or for without cause for convenience. Mr. King is the chair of that commission. He can decide, although he says he's never not allowed someone to speak, he has that authority and that power to accept a memo for the commission in regards to performance by mitigation specialists, and to say, under the bylaws, I'm not going to hear from anybody. We're just going to take a vote on this. That's incredible power. And like I said initially, this is kind of a structural conflict, Judge, that people shouldn't be allowed, to wear those two hats. There shouldn't be a state attorney prosecutor in our case, and then wear another hat with the commission, with the authority, if we've heard from Ms. Martinez and essentially acknowledged by Mr. King, to take away our mitigation specialist at any point during the progress of the case. Now, Ms. O'Shea, the issues that she had were not related to the Lloyd case. It doesn't mean that in the future that couldn't be possible. And they apparently going to allow her, which is to, although not to renew a contract, they're saying, well, you can continue to work on this case. And certainly that any attorney is going to have some concerns about, the question about the confidence that we would have in her in a case in which JAC has said, we're not going to give her another contract in the future. So they have the ability to... Are you saying you have a lack of confidence in Ms. O'Shea? Or are you saying that there's just a structural problem with the legislation and the staffing of the JAC, or the composition of the JSA? Well, there's been no issues brought to my attention. Okay. So you're confident in her? Well, at this point, that's correct. Right. But, obviously, going forward, knowing that she has issues with the commission, it's always going to be kind of a cloud over our heads about, well, at some point, are they going to say, well, we still don't like how she's billing, we're going to take this back to the commission, present it to them for voting about, whether they're going to allow her to continue working on the contract? Well, I think that, I don't apologize for interrupting, but that last issue I thought had been decided. The commission has kind of unequivocally said that she is not on their approved vendor list. So if someone entering a contract with her, she cannot bill us directly as after July 1st, 2018. We will not pay her interim bills. I think that's beyond dispute. I haven't heard any that's intention. And then I thought Ms. Martinez said for 22 cases, Markeith Lloyd being one of them, where she has been approved by the court to operate as a mitigation specialist, those bills will be paid. That's not to say the JAC can't audit the bills, question the bills, adjust the bills, but not that they will take the position of we're not paying her because she's not approved for payment, just she's got to meet their billing requirements, whatever those might be. That's what I understood the position to be, but correct me if I'm wrong. No, I agree with that, Judge. Okay. What I'm saying is, it would appear to me that her ability to continue on with the contract, even though they're not going to renew the one in the future, she would still be in jeopardy on those 22 cases she's working on in terms of being reviewed by the JAC and then making another decision. Because if you look at the minutes, I believe the minutes for May 23rd, they instruct the staff to continue to look at her bills. And right. So there's that danger at some point they could take something back before the commission and say, hey, we want to terminate this woman's contract now, yank her off for all these cases. Well, common sense tells me that they are going to look very carefully at her bills. They're going to scrutinize her bills. If they believe, as apparently they do, that she either double billed for activities or billed for activity that is
compensatable, I'm not even sure that's a word, but for which we don't compensate under the contract. I would think going forward they're going to scrutinize her bills very carefully. I think common sense would dictate she knows that, and the commission will do that. It's speculative whether they would say in fact, they've testified under oath that they will honor her contract, her relationship for interim billing in the Lloyd case and 21 other cases where she's currently been approved as a mitigation specialist.
That's the position this time.
Right.
But they can change that position.
Well, sure, anything could happen going forward.
Commission, they go before the commission, Brad King is the chair, and he can say, although he said he's never done this, the bylaws allow him to say, I'm not going to hear from anybody, we're going to make a decision, and he's allowed to say, we're going to terminate this person's contract and take away defense counsel's mitigation specialist. And
that's your structural concern?
Yes.
Okay, all right, I just want to make sure I understand it. Very good, okay, thanks.
Now, first of all, not only has there been any demonstration of prejudice to Mr. Lloyd as a result of this, there's been affirmatively demonstration that there is no actual prejudice here, in the sense that there is no confidential work product or anything else that has gone from Ms. O'Shea to the prosecution in this case at all. And Mr. King's position on the case, the commissioner didn't change that. So there is no prejudice here that can be demonstrated. I think what, at best, in the light most favorable to what they have attempted to show is that there is some appearance of prejudice by a theoretical action that could be taken in the future. And that's where we are. As to the argument that somehow the fact that JC has oversight over the spending has a chilling effect, well, somebody's got to oversee the spending, unless you just give these providers carte blanche to spend taxpayers' dollars as they please. If JAC was disbanded and the function was moved under the Commission Department of Agriculture or whomever, somebody's still monitoring this, and so that chilling effect isn't going to go away. That's just somebody's looking at the bills and going, hey, wait a minute, these bills are out of line.
Well, I accept that, but it is one thing to say a agricultural commissioner will review with the assistance of staff the adequacy of bills. It's another thing to say that the prosecutor assigned to the case, because the legislature has legislatively constructed this commission to operate this way, ultimately has some authority, yea, to approve or disapprove contracts or maybe even individual payment. I mean, that's different than just some other state employee unrelated to the case being in an oversight capacity.
Granted, but if that creates an appearance of conflict sufficient to remove the prosecutor, that means that the state attorney of the Fifth Circuit and the state attorney of the Sixth Circuit can no longer carry out their responsibilities of any case where JAC is making payments to anybody.
Well, and there hasn't been an attack on the constitutionality of the statute, so I don't have that in front of me. No. But I have a different attack, which is, in this case, Mr. King is the state attorney and he's the chair, and this commission authorizes payments. I don't know that there's any evidence that privileged information has been disclosed, which is one reason I asked the question. And Mr. Whedon's argument is there's this structural impropriety, and either an appearance of impropriety or actual impropriety. Certainly, I think his argument is that structurally it has the appearance of impropriety. Most of the cases I've read in this area, of course, deal with former counsel for someone working for a prosecutor. There's many cases in that area. There's not a lot of cases. Maybe there's an investigator case where someone became an investigator for the state. That's where most of these cases come up.
And it's not just a question that the former defense attorney is now working for the prosecution.
Even that's permissible if there's a wall?
Well, and even if there's communication.
There was that one case, right?
That was both. That there was, in fact, communication. And that distinguishes Castro. Because Castro goes beyond actual communication. It goes to material assistance to the prosecution. They said that created a sufficient appearance of conflict.
Although they say in both cases that it is unwise to ever have former counsel even speak to the prosecutors who are
They
prosecuting.
did, and in the Bowe case, they made it clear they agreed with the trial court. They said that conversation should have never taken place. But they said that still did not create such an appearance of impropriety that in that case it required disqualification of the office. A case more squarely on point, it is the third DCA case that I cited, State versus Nolasco, where there was an ex parte hearing regarding the appointment of an expert. And this was a case that occurred in Dade County. It occurred at a time when the counties were paying the bills. In that case, the county attorney appeared. The state attorney was not noticed. The state attorney didn't appear. There was an ex parte hearing held. Practice had been the transcripts of those hearings were sealed. Well, because of a mistake by the court reporter in that case, the transcript was sent to the prosecutor, who actually read the transcript and became aware, as the defense pointed out later, of their roadmap where they were going in mitigation, and actually became aware of a witness that they would not otherwise have known. The prosecutor in that case said, I don't have any interest in that witness, and unless you're listing, I'm not going to be involved in it. And there the DCA actually reversed the trial court, which granted the motion to disqualify, saying that doesn't create such an appearance that there is no demonstration of prejudice even in that situation. So here we're even further removed, and that what we're talking about here is a theoretical future action which could prejudice the defendant. And it was not to the point where we've reached the threshold of an appearance that even exists is so great that it calls into question the integrity of what we're doing.
All right, thank you. All right, I want to reread these cases. I want to read the exhibits or evidence, Madam Clerk. You didn't mark that because I do that states one. And I'll prepare an order and I'll let you know. I'm proposing that we meet on the 26th at 10 o'clock. Can you check your schedules?
Buxman and I are available, Your Honor.
All right. Mr. Whedon? Oh, 10. Might you be in a trial then? That's 2 weeks from now.
I might be in trial. Our trial schedule will start on the 18th. If you could do it like at 8:30,
I can. I'm going to make every effort. I have a doctor's appointment at 7:45. It's the same one I had today. I think I got here about 8:35. That's the only thing, so let's schedule at 8:30, but give me 5 to 10 minutes. And the other thing is, if you will let Ms. Washington know if you're in a trial and that's the issue, then I'll speak to the trial judge to say, can you maybe start just a little later? Although we've got a few things to cover. How long is your trial anticipated to go?
I'd say 2 or 3 weeks.
Oh, that long. I see. Okay.
Jury selection may take the first week.
Let's tentatively set it for 8:30, but I'll get back to you all. I'm going to talk to the Judge Harris. So I'll talk to the trial judge to see what's going on with that. But I'd like to get together and let's shoot for 8:30 that day. So we can talk about scheduling and other issues. All right? Any questions? I'll have an order for you by then on this matter. Okay? All right. Thank you all. Appreciate it.